Good morning, everyone in business law. I thought I'd put up a quick video about Chapter 31, the dissolution of the partnerships. The one thing I didn't really like about this chapter is they didn't stress that under the new revised Uniform Partnership um, uh, Act, which has basically been adopted in every state pretty much universally, now there's an expectation or a presumption that after one party or one partner leaves the partnership, there's no longer going to be dissolution, whether it's because of death or insanity or expulsion. Basically, now, and the book doesn't stress this enough, and it should have done it right at the beginning of the chapter, it says under the Uniform Partnership Act, the rules have changed. A partnership may be continued when a partner departs and the remaining partners decide to buy out the departing partner's share. There's a little bit of a tongue twister there. But the concept for a long period of time was when a partner left, whether it's through death, expulsion, voluntarily just wanting to, whatever, retire, leave the partnership, go on to some other aspect of it, the remaining partners couldn't continue business as that partnership. They'd have to form a new one and therefore notify all the creditors, end or wind up all the pre-existing contracts and kind of start new, which was, pardon my French, but really kind of a pain in the ass. And so the way in which the revised Uniform Partnership Act, that's like, again, adopted throughout the United States and all states with some slight variations, there was a recognition that oftentimes remaining partners wanted to continue on. Now, historically, before that revised Partnership Act took effect, partnerships could have always put that in the written agreement. Now, remember, you don't have to have a written agreement to have a partnership. Two or more people get together for a business end meeting to make profit. That's a partnership. You don't have to have a written form to actually make it happen. But a thoughtful way in which you want to develop a partnership is to put in provisions about what happens when one member or two members leave the partnership. Will it be able to continue? Must it dissolve? That's one thing you can still do, and that's the only way previously a partnership could continue if one of the partners had left, died, was expelled from the partnership entity. Not anymore. Now there's kind of a recognition that, say we had 5 partners in an entity, one decides to go on to greener pastures, follow a different career path or whatever it is. When they decide to leave and give notice to the other partners they're leaving, historically, if the partnership didn't have a written agreement that the remaining partners could continue the business, it would have to basically shut down and wind up the current contracts. Of course, the 4 remaining people could start up a new partnership, but they have to go through that notice process with all the creditors and wind up the previous contracts and distribute funds to the exiting partner. Now, the law presumes the 4 remaining ones probably will want to continue. They don't have to, but they could, and they don't have to go through any special mechanism. They should still give notice that, hey, one of our partners is retiring. We wish him the best, and give notice to all the creditors and those contracting parties with the partnership. And they have an obligation to distribute that the exiting partner share to them. They're entitled to the previous capital interest that they have. And it's another good idea to have a written partnership agreement to say, well, how are we going to come up with it? What if we have a very large partnership entity? We own a lot of properties, we own a lot of equipment, we have a lot of assets, and now one of our partners are leaving, and say we're 5 partners, they're entitled to 20% of the equity in all of our ownership. If we had to liquidate, the firm can't continue. It's going to lose its ability to go on. And that's why historically partnerships did dissolve when one partner left. So what would we probably want to have in that written agreement is a means by which we could either refinance or have a way in which we could continue the partnership without it being crushed, a 12-month provision that we'd be able to wrap up the ability to get funds to buy out that partner. Now, when we buy out that partner, we'll say the partner died, we'll get into that in a second, but a lot of people think, well, now they say my dad was in a partnership, my dad dies, do I get to become a partner if I was his only heir? No, but I'd own his interests. I'd be entitled to get, either I could remove the interest from the partner, or I could basically become a silent partner and still share in the profits that my father would have been entitled to. But I don't get to exercise any management or control over it. The continuing partners that do have control have to exercise judgment as a fiduciary for my benefit, but they don't have to consult me, nor can I participate in the management of the firm. So dissolution of the partnership, they give the different ones here. One's by agreement. We could put right in agreement, this partnership dissolves on such and such a date. You could literally put an end date on it. I don't think many partnerships do that, but sometimes a partnership's designed for a specific project. We're going to create a partnership to build, I don't know, a building or something like that. We're a couple of different contractors. We decide to enter in a partnership for that. Usually if it's for a limited duration, we often call that a joint venture, but it's very similar to a partnership, and we can actually create it as a partnership with an end date determination on a project or simply a date. Withdrawal or alienation. And that's the big one. Oftentimes a partner decide, working with these people isn't just for me. I want to go on my own, or I want to have a different sort of, perspective on how businesses run. And that's withdrawal. Withdrawal would historically end the partnership. And we know under the new I can't stress this enough, under the new revised Partnership Act, the remaining partners can still continue on if they wish to do so. What does the withdrawing partner have to do? They have to notify the other partners. Now, what if we had a partnership agreement? We decided we're going to do this for 10 years. I withdraw 5 years into it. I'm leaving early. I'm liable for any losses the remaining partners have because I breached the contract, but that doesn't mean I can't withdraw. You can't force people to stay in a partnership even if there's a written contract otherwise, but I'm subject to damages, obviously. Let's assume they don't really suffer any financial loss. What do I get? I get my partner's interest, and there's a process by which we determine what I contributed to the partnership. I'm entitled to get that first, and then if there's any other share of assets and equity, I get to get that upon removal. You should put in the written agreement that the remaining partner should have a period of time to be able to do that. Otherwise, it would destabilize their ability to continue, and that's why they'll ultimately might require the partnership to actually dissolve because they can't continue on by having to pay me out. So withdrawal or alienation. Alienation is this thing, and sometimes it does get funky. One person's just not doing their job anymore. They're not showing up. We can decide to expel them. You should always have a written agreement spelling out what it takes to expel somebody. But if you don't have that, you can actually seek a court decree, or you can try to push them out by requesting them to leave. They're entitled again to their contribution and to their share of the equity in the partnership's assets. But alienation does have quite a bit, and I wasn't involved in it, but I had a friend was, and they were asking me to consult on it a little bit, where these three people, all three of them hated each other. It wasn't like 2 against 1, 1 against 2. All three of them hated each other. They all had different decisions about how to go. It became almost a futile business practice to continue on, and they ultimately had a court decree that they had to dissolve the business as a partnership and distribute the assets, and they all went in their own way and opened their own new firms in the same business area, but they couldn't continue on working together. It was the business goal was frustrated, and you can get a court decree doing that, and that goes up next. And then expulsion, I went over that. Now, court decree, insanity. Insanity has to be permanent or expected to be permanent, or at least ebbing and flowing, and you need a court decree. It's not up to the other partners to say, hey, Jim is suffering from insanity. We're going to expel him and give him his share of the partnership assets and move on. You need a court decree to prove insanity, and it usually has to be the kind of insanity that's going to be either permanent or likely to be a recurring problem to really meet the goals of the partnership purpose. Incapacity, same rule. You have to get a court decree to say you're incapacitated from doing it. If I'm an attorney and my role in the partnership was to do oral advocacy before a trial court or an appellate court, and I lose my ability to speak and or write for whatever reason, a stroke, and there's no real reasonable accommodation that could allow me to go on and perform those functions in the partnership, I could either consent to withdraw, or they could try to get a court decree saying incapacity makes this person unable to go. That doesn't mean it's cruel or anything. Well, I feel like I'm a mafioso saying, it's just business. It's nothing personal, but incapacity. Misconduct's a big one. If we've got a partner that's stealing or doing fraudulent activity or doing any act that's inconsistent with the partnership's interest or goals, that you can get a court decree as well, dismissing it. And futility. Futility comes up a lot. I think about, I don't know why, I have no knowledge about the restaurant industry at all. I don't even cook at home. I'm terrible at it. I barely boil water. I don't know. It's one of those, fantasies about owning a restaurant. And every so often I've talked to different people about potentially getting involved in it. Now I've hit an age where I know I'm not going to have it happen. But restaurants often fail, even good ones with good business models. And it seemed like they have a lot of activity often go under. And so sometimes you'll have a business that, they've done everything they can and it's going on for a year and year, and there's really no hope that it's ever going to turn a profit. It's similar to bankruptcy, but it's not. It's basically a court decree recognizing that no matter what we do, it's probably never going to turn the page. Remember what a partnership purpose is for. Partnership is to seek profit. And if there's no hope for that, that's called futility in this accordingly. Outside of dissolution by court, it's very much related, but it's operation of law. One is death. Any partner dies, technically the entire partnership needs to be dissolved. However, we know by the Uniform Partnership Act that the remaining partners can continue, and they basically pay the estate, the heirs of the decedent partner, the profits and or interest in the partnership. Bankruptcy, if any one partner is bankrupt, that partner, it dissolves the partnership, but the remaining partners can again continue the business, but their portion needs to be liquidated to pay creditors. And then illegality. I know that sounds a little weird, but it's kind of obvious if you think about it. If the partnership was formed today to, I don't know, whatever's legal today, I don't know, maybe harvesting certain kinds of seaweed is legal, and all of a sudden the seaweed beds become a rare species, and the federal government decides that you can no longer commercially harvest seaweed for the sushi industry or something like that. Our purpose is now illegal, and therefore the partnership is dissolved by operation of law. The big one again about notice of and when it's dissolved, it's dissolved for illegality. It's stopped right there. But if it's futility and other purposes, or people want to withdraw and just simply move in different directions, you're still allowed to continue and finish the contracts you currently have, and you're also allowed to enter into minor contracts to finish the major So say we had a contract to got to finish this 3 houses. Well, we can obviously go to the lumber supply company and enter into contracts to get the lumber to finish up those projects that were already part of the contractual obligations that we had. It's called the winding down. Sometimes winding down can take quite a while because there's outstanding contracts that need to be completed. And then notice of dissolution is big. So say we're in a law firm and I have 4 partners with me, and we decide, because I only want to work in a certain area, and and the other ones really are about money and I'm more about, like, I don't know, just having a modest practice, and we decided to break up. That partnership will become dissolved, but it's very important that we give notice, and usually try to get the positive way. Say, hey, because we're hate each other now, we're not getting along, or we have different dreams and ideas, we're breaking up the partnership. But you can do it in a very positive way through mail, in notice of newspapers or in legal journals and things like that. You should notify everybody, because if people think we're still a partnership and my partner Jane or Bob goes out and enters into certain contractual obligations, and that third party reasonably believes we're still functioning as a partner, I'll be liable on those contracts. So it's important to give out notice. Notice is the real core of what we call due process of law, because it really is about due process. Everything that we put people at sort of at stake of losing money or risk, it's all about notice. If you don't get notice, and if you don't give notice, it's deemed fundamentally unfair to the party who hasn't received notice. So it's really essential to let them know they're not authorized to enter any contracts. But you can do it in a very polite, positive form. So I used to read a newspaper quite a bit called Lawyers Weekly, and every so often we'll say, the former law firm is so and so, closed on such and such, but we're proud to announce the following new affiliations opened up. And what they're trying to do is to tell you that certain people are no longer affiliated with the other members that are continuing on in a different under a different firm name. I think it's a pretty clear chapter. It's pretty simple. Look at that. I kept it down under 15 minutes. That's a miracle for me. And next, we're going to jump into a very important chapter. Corporations. Be well.